Okay, now these have been mapped out in an interesting sort of a way, and they're trying to find logical divisions between the various topics in trusts. I found quite challenging going through when trying to structure this course, and really trying to, for each particular recording, to make it different and distinct from other ones. So you'll notice that in the previous recording it had talking about powers, but also the corollary duties as well. Sometimes these things overlap. And so what I have found is that for this particular part, I just managed to bring up my screen, when we're talking about the rights of trustees, they really kind of flow from the powers and the duties. So just be mindful of the fact that some of these things are, essentially they just overlap each other quite carefully. It's not a clean, separate area of law like you'd expect in some sort of areas, in other sorts of subjects. And so start with the, I guess, the right that I've already referred to in the previous one, which is to right to reimbursement from the trust funds. Section 72 says expenses that are properly and reasonably incurred can be reimbursed from the trust funds. Trustees do their job properly, actually don't have to fork out personally for things that they've done while wearing that hat as a trustee. I mean, that just comes from the statute itself. It can't be overridden. Now, that's fine when there is trust funds available to go through and do that. But as you can imagine, like a lot of these situations, it's when something unusual has happened and the trustee, for whatever reason, can't do this or can't use this simple right. So the first thing is to ask whether or not they have rights to get things from beneficiaries. Because if we think about it, we as trustees are acting or trying to act for the benefit of the beneficiaries. And so if we are seeking to be reimbursed and the beneficiaries have taken the money away or demanded for the trust to end, in theory we can't be reimbursed because there's no property. We've got no right to seek compensation from anywhere else. There's no equivalent of like the QLS have fidelity type funds for trustees in the broad sense. And so that idea of being able to get money from beneficiaries or from third parties or from the settlor themselves, none of those are going to apply unless it's been mapped out of the instrument, subject to one exception. This comes from Hardun and Bellius, the case which is on the slides. And that's where there's a bare trust. In other words, the trustee is merely holding the property, and the trustee has actually, in the case of a situation, contacted them and said, hey, you're sui juris, we are holding this, but we're only holding it as bare trustee. We're not doing anything else in regards to it. We're just waiting for you to come and essentially get your stuff for us to deliver it to you. And so this, and that's what happened in Hardun and Bellius, where there was a sole trustee and sole beneficiary, and the trust assets were shares, and there were shares in the Chinese and Japanese banking corporation. And the trustee held them as bare trusts, so all they were doing is just holding them in name in order for the beneficiary to demand transfer across. And then they sent letters to the beneficiary saying, hey, we would like to end this trust. Can you please do this? And the beneficiary refused. And the difficulty was that in that situation, there were these shares for this company, all right, and you may or may not recall from company law, as a shareholder, the only thing that you owe as a shareholder is the value of your unpaid share capital. In other words, if you purchase shares but haven't paid for them fully, that is the only thing that can be demanded of you. It's the whole point of limited liability companies, is that we don't place demand on shareholders. They just own a packet of the company and occasionally get distributions and then can on-sell those shares at some stage later, possibly for a capital return. We don't place duties upon them other than one, which is that they have a contractual obligation, which is also enshrined in statute in our Corporations Act these days, to pay the amount of unpaid share capital. So in other words, if you've bought 100 shares for $1 each, but you've entered into a contract to do that, but you've only paid 50 cents, and then the company goes into liquidation, the liquidators can ask for the other $50. And that's what happened in Harun and Valius, because the shares had been half paid for in the Chinese and Japanese bank, which there was war, and that bank went belly up. The shares became worthless. And so the trustee at this situation is trying to seek reimbursement. And we've got a bit of a problem here, because again, there's nothing in the trust fund other than this this bare right to go through and get or recall the money from the beneficiaries. And so in this situation, quite a narrow set of circumstances, where there was a sole beneficiary, and they were presently entitled to it, then that could actually be demanded from them directly. It's one of those narrow situations where a trustee can actually make demands and take money away from money which is in theory going to be owed to beneficiaries. And that's it in that situation. And that Brumhead case, Harden and Bellis applied to a sole beneficiary in a bear trust, and Broomhead and Broomhead, both companies, a little group of companies, and there they said that in that situation where all trustees can demand from all beneficiaries, they can do so as well. Because again, if they can demand it from all of them, there's no prejudice to other beneficiaries. All right, another situation is this idea of subrogation. And again, this may have come up in company law. I'm not sure for you guys. I recall studying this when I did company law in New Zealand many years ago. It's that idea of being able to, for the creditors, who normally don't have access to the property of a trust, it's held beneficially for the benefit of for the beneficiaries. But there are some situations where where creditors are owed money, where they can essentially ask the trustee to step in and exercise their right under Section 72. And that's one of the few situations through the mechanical operation of law where creditors are allowed to go through and do this. In situations where they are owed money, only the trustee can do this, and only because they have the statutory right. Okay, now, right, this right to contribute, or rights to contribution. It's one of the concepts I actually found that possibly I wasn't paying attention in law school enough. It's something that came up in legal practice, this concept of joint and several liability. I'm not sure whether you guys have been exposed to this, that there are some situations where several people are held jointly liable for something. What that means is that you can go and seek money from some or all of them. So the example that came up for me in legal practice was the breach, the sexual harassment legislation creates a statutory duty. Thou shalt not in employee-related situations sexually harass employees or colleagues. Okay, it's pretty straightforward statutory duty. And breach of that statutory duty gives the innocent side the right to seek compensation. But they can seek compensation jointly and severally. In other words, they can seek it against the person performing the sexual harassment, but in many situations, it's a fellow employee. So you can also hold the employer jointly liable. And this comes up with liability and trust law as well. because if there are between 2 and 4 trustees in a private trust, or an arbitrary amount for a charitable trust, and there is a breach, all of the trustees by default are liable to contribute. And so the beneficiary can seek compensation from one or all of those trustees. You can ask, say the breach is for $10,000, you can actually sue each of them to try and get the money out of them. And so that if through this process the beneficiary chooses trustee A, or say there's 4 trustees, they choose trustee A, the breach was for $10,000. $10,000 can be obtained from trustee A. Then that trustee has a right in equity to seek reimbursement or compensation from the others. We can see where this is going, because we know when things are done in equity that conduct of the party matters. And so that idea of using the rules of equity in order to seek, and they call this contribution, it's the name of this area of law, is done in equity, and it's designed to try and reach a just and fair result in regards to all of the people who are held liable. The trouble is in this area is that often the trustees aren't all equally culpable. So one trustee may commit the breach and other trustees may be liable to pay for it. And so this Chillingworth and Chambers case, the rule from this is that in situations where there is a trustee and they're the one who has committed the breach as well, all right, this is going to interfere with equity's ability to try and rectify this situation where there is this equity as equality system to try and seek equal contribution in situations where their other beneficiaries have gone to court and sought remedy against one of them. What I mean by that is that if the beneficiary who is the trustee, but trustee is a beneficiary and they are the one who's committed the breach, then clearly equity is not going to allow this doctrine of contribution to somehow prejudice the other trustees as a result. So again, this is one of those rare situations where the beneficial interests of a beneficiary can actually be accessed in the situation where they're trying to determine how contribution is going to work in regards to joint and several liability. So usually you can't access, third parties can't access the beneficial interests of trusts, but situations where there is a breach and the party that was somehow involved in that breach is also a beneficiary, that beneficial interest can be accessed in order to resolve the issue of contribution amongst the trustees in terms of who has to pay. Does that make sense? I'm sure I explained that particularly well. Not particularly? I'll try again. In lots of areas of law, you can be jointly liable for things. So let's just say all of us are company directors. We've all breached our fiduciary duty through not checking on a series of investments. The what's another beneficiary in that case? What's the word? The shareholders. We've breached our fiduciary duty to the company. So shareholders, as you remember, on company law, can step in the shoes of the company to sue us, and we can be held jointly liable. What that means is that if Andrew has a lot of money and the rest of us have nothing, they can go after him, get the money off him, get this much money off him. He then gets a right in equity to seek contribution from the others, but the conduct of the parties matter. So if we're all equally liable, and we're held jointly, severally liable, then in theory, equity is equality. We'd be able to get an even amount from all of us. In practice, though, some usually are more blameworthy than others, and equity won't allow that injustice to occur. So when doing this contribution doctrine, they will take that into account. And in situations where these trustees who are blameworthy, somehow at fault, are also beneficiaries, that beneficial interest can be used to satisfy the doctrine of contribution. That's how that works. Okay, impounding. Okay, so in situations where you've got multiple beneficiaries and one of them asks the trustee to commit a breach, one of them has asked them to misuse and misappropriate trust property, again, usually to the prejudice of the other beneficiaries, then their interest, the beneficial interest of the beneficiary in the situation who's at fault, can be impounded. In other words, quarantined and prevented from being disposed of or requested, in order for that to be essentially that amount to be dispersed to the innocent beneficiaries in order to restore their economic positions. Basically, and this flows from this idea of equity as a court of conscience. In situations where the beneficiary has caused the trustee to commit a breach, they can't benefit from it. And their beneficial interests will have to be consumed in order, to some extent, in order to satisfy the loss that the other beneficiaries, the innocent beneficiaries, have suffered. And again, this can come up particularly in closely held family trusts. This might pop up in things like exams. Okay, trustees as a breed, by default, act gratuitously, so they don't get paid. That's the default position. Being a trustee only comes with burdens. You can't be paid for doing it. You can be paid, reimbursed is the word they've used here in section 101, if the instrument lets you do it. So in other words, if the trustee, if the settlor has intended when creating this particular document, either a testamentary trust or an inter vivos trust, if the intent is clear that they want some fraction of the trust property to go to trustees, maybe to make sure they do a better job, maybe that's in the economic interest of the beneficiaries, that's fine. If the instrument provides that can happen, that is fine. Trustees can also be reimbursed by unanimous assent of all beneficiaries. Again, this is a pretty logical, pretty straightforward thought, because if you stop and think about that, if all beneficiaries come together and can agree on something, it's essentially like they're just clipping a little bit of each of their beneficial interests, handing that back to the trustee. And finally, if the court can order the trustees being reimbursed in situations. And in this day and age, you have professional trustees, had professional trustees for a long time. But it's that idea, particularly in the modern world, where things like investments get a little bit more complex. There's this trend towards moving towards having a service-based economy rather than everybody being able to do everything. There's a tendency to move towards a specialization aspect. And one of those things is that, look, if you don't have the expertise to be a trustee, pay someone to do it instead. In theory, they'll know what they're doing. All right, so finally, one of the rights that trustees have is the right to go to court. And they can go to court in a variety of ways, but really, all of these are for their benefit. Trustees trying to fulfill their duty in situations where they don't know how. If it's not clear what to do, trustees have a statutory right to just go to court and seek directions. They're allowed to go to the court and say, hey, we have this problem. Can you sort that out? Finers in Miro. Finers in Miro, that's the case citation. I haven't put it on there for whatever reason. They can go to the court, ask and seek directions, and they can pay trust money into court as well. So asking directions, 96, 97, paying money to court, and 102. And the final thing to note is that they, in situations where the instrument is flawed or somehow problematic, or the trustees wanted to depart from clearly expressed instructions, and the statute doesn't empower them to do that, obviously the statute's going to override the deed in most situations, most of all situations, unless the particular section in the Act provides that the instrument will override it. If you can't do that, you can go to the court and just get their permission to go through and depart from the instrument itself. That's section 95, and that's the kind of the last thing that I have to talk about in regards to this. It does seem a little odd. You may notice that when going through and doing and talking about these, that this intersection between trustee duties, trustee rights, trustee powers, sometimes the boundaries are a bit blurred. So just make note, the rights kind of correspond to the powers, and the duties correlate to their powers as well, because the powers only flow from them trying to fulfill their fiduciary duties, and the rights flow from them having powers. So this, I've tried to separate these out conceptually as best I can, but it will take a little bit of thought going through and analysing this, particularly in regards to exam type scenarios where we're trying to work out in any given situation what is the legal issue here. And look, it's very much a shotgun, not a sniper rifle. We're not looking for precise answers from those things. Often there are multiple issues that will flow from one particular fact. The trustees will have a duty and some powers relating to that duty and some rights that they'll have, usually for reimbursement in regards to that as well. So you guys will have to think about all of these areas when we're going through and answering these. So I hope that was useful. I'll end the recording now and we'll wander across near the tube.